Hello there, and I want to speak to all of you artists out there today and talk to you about 3 steps that you can take to protect your artistic legacy. And although death is probably a long way off, it is important that you have a plan now to ensure that your affairs will be settled in the way that you want. And an estate plan crafted by an experienced estate planning attorney is a legally enforceable set of documents that allows you to name who will have the authority to make decisions for you in the event that you cannot. So that'll be your financial power of attorney or your medical power of attorney. Who will take care of your minor children if you had any, so that's someone who's going to be their guardian. Who will wind up your affairs upon your death, so it might be called a personal representative or an executor or a successor trustee if you've done trust planning. And also who will receive your accounts and your property and your artwork. And those are just the beneficiaries. So you do have some options regarding who is going to receive your artwork. So you could just tell or instruct your personal representative or executor or successor trustee to sell any of your artwork that you owned when you passed away. You could designate specific individuals to receive it, or you could have it held in trust by a foundation to be lent or licensed after you've passed, or you can provide instructions to donate your work outright to a museum or a university or some other organization that might benefit from it. So let's talk about the steps you need to take in order to begin this process. Now, the first step is to catalog your artwork, so including pieces that you may have sold. Make sure to specify to whom they were sold and for how much money. This information can be helpful in valuing artwork that has not sold and providing a list of potential buyers for when you pass away. You should also include any pieces of artwork that you have lent to other people or charities or organizations. This knowledge will be helpful for your loved ones to determine who has the artwork and under what circumstances it will need to be returned. Your list should also include any pieces that have been licensed to someone else. It will be important for your loved ones to know about these streams of income, which could continue after you've passed away. You also want to consider including a list of pieces that you have gifted to individuals or donated to charities. So be sure to include any pieces that you have kept for yourself. Now, after you've compiled this list of artwork, it will then be important to determine the value of any piece that has not already been appraised and that is still considered yours, having been neither donated or sold. Now, this process can help you understand the value of everything that you own, and that's an important step in the estate planning process, and to help you determine if you have adequate insurance to cover your artwork's value. Just like other pieces of tangible personal property, your artwork can be susceptible to theft and destruction and really needs to be protected. The last step for you is to meet with your estate planning attorney or to review your current estate plan. Then you can discuss to whom you want to put in charge of your affairs when you pass away, as well as any period where you may be incapacitated and unable to make those decisions for yourself. You also want to discuss your wishes regarding your artistic legacy. So you want to air your fears and your concerns and your objectives to make sure that you have a unique estate plan in place that addresses these concerns. Another thing you want to consider is copywriting. Now, copyright protects original works of authorship, such as books and movies and songs, computer software, photographs, and architectural works. These works do not have to be published to be protected, but they generally have more commercial value after publication. If you own the copyright to your artwork, both the work and its copyright should be included in your estate plan. If the copyright is not specifically mentioned in your will or trust, it will transfer to your heirs by a residuary clause, which distributes all property not already addressed. As a result, one person could end up with the work and another with the copyright. However, it is important to note that a copyright includes your right to terminate most transfers or licenses of the copyright at a future date. Now, you cannot waive or transfer this right to someone else during your lifetime, and it passes to your surviving spouse and children when you die. It includes the ability to terminate a transfer of a copyright to a trust. An exception to this rule is transfer of the copyright by a will, which cannot be terminated by your spouse and children under the law. So I understand how overwhelming it can be to think about what to do with all of your prized artwork when you pass away, and to make other important decisions about your care and the care of your loved ones. So we're passionate about helping people create their estate plans. And if you need an effective estate plan in place, make sure you contact your experienced estate planning attorney to help you with all of your artwork. So I want to thank you for watching. I'm attorney Kelly Longtin. Please remember to like and subscribe to our YouTube channel. I'll see you all next time.